And as you're answering that, I'm going to go ahead and introduce our presenters today. Today we have Joshua Lester. He's with the Equal Justice Works. He is the Equal Justice Works legal fellow. He works with the Medical Legal Partnership at Children's Hospital for Arkansas Legal Services. And we also have Jay Coleman. He's a staff attorney with the Center for Arkansas Legal Services. And I'm going to end this poll. And it looks like about 45% of our attendees say they're a novice, 34% say some knowledge, and 21 has firsthand experience. And looks like I've accidentally clicked through some slides. I'm going to go ahead and turn over to Joshua Lester to get us started on the presentation.
Okay, thanks, Christy. Thank you all for attending. We've had great attendance, so we're really excited about that. I think the overall CLE was maybe more oriented towards parents and non-legal advocates, but that's great that we have so many attorneys attending. I think in terms of the poll that Christy just shared, it'll offer some great information for other attorneys as well. To start out, we'll just talk about education law in general. In terms of law and what we look at in terms of basically just breaking down education law is a huge subset. We really look at Section 504 of the Rehabilitation Act, and that kind of goes hand in hand with Title II of the American Disabilities Act. And we will briefly talk about the IDEA, Individuals with Disability Education Act, but breaking that down further, discussing some issues and things that come up in terms of evaluations, actual services under the IDEA, and placement. In education law, you can't skip over suspensions and expulsions, and those also go hand in hand with the IDEA. And also included in education law would be any issues arising from language access and education as second language services. We won't be covering anything over that today, but that's also something to keep in mind while we go over the CLE. And of course, discrimination, harassment, and bullying. And Jay will cover some due process complaints and towards the end of the CLE. Education law in general just kind of presents its own challenges due to the wide range of barriers our clients are facing. I think any attorneys listening here who kind of focus on education law in general understand that our clients are having a lot of other external factors going on, whether that be housing insecurity, trauma, or income insecurity as well. You can go to the next slide, Christy. For today, the real focus is just focusing on legal avenues for services. So we'll mainly be speaking on 504 and IEPs, but within each of those subsections, each of those legal avenues, I'd say, we're going to be discussing some common pitfalls. And that's really where we're targeting either non-attorney advocates or non-legal advocates or parents, and offering some information on what we see in terms of attorneys as the common pitfalls in securing those services for your students or children. And then overall too, just keep in mind our clients' considerations. What are we trying to obtain and why? What your client is trying to obtain and why? And when does your client need it? And I think that's very relevant. As of now, I'm not sure where everyone else stands, but school's about to end here in a week or a couple weeks in some spots of Arkansas. So that's something to keep in mind if you are presented with one of these cases. And then I know here at Legal Aid, we're always trying to address systemic change. So in speaking in education law, that's really kind of goes to a lot of things. Like I mentioned in the last slide, there are so many other external factors usually impacting the legal services needed for education law. And so you can't just look at systemic issues for education. You're really having to look at all sorts of other socioeconomic issues in terms of housing insecurity or income insecurity, things like that. So we'll kind of be speaking on those issues as well throughout the CLE. Christy, you can go next slide, please.
Sorry.
No, you're fine. So here are some key terms. We're probably going to be shorthanding everything throughout the CLE. B and J will. Of course, we're just going to refer to 504 plans under the Section 504 of the Rehabilitation Act. The alternative learning environment, what's called as ALEs, and that's kind of I think actually that term kind of came out of the legislation for No Child Left Behind Acts. I'm not actually sure about that one, but we will talk about alternative learning environments and how those fall into the legal avenues we discussed with the 504 and IEP plans. And Jay is going to cover the behavioral intervention plans and the functional behavioral assessments. FAPE, we can't skip over free appropriate public education if we're talking about 504 and IEP plans. And we already talked about the IDEA. IEEs, or independent educational evaluations, I'll discuss that in more detail when we go over gaining IEP services and specifically the evaluation portion of that. An IEP least restrictive environment is definitely something important to note, just due to the traditional view of when, unfortunately, students who had disabilities were segregated from the rest of the school population. Now we acknowledge that that's definitely not appropriate. There are different standards based on a students' disabilities in terms of how often they are kept with what we call a traditional classroom setting and not. But the goal is to have students who are disabled um, educated with non-disabled peers to the fullest extent. And Jay's going to cover the manifestation determination review, related services, and of course SPED for special education. And Christine, go on the next slide, please. Okay, so this is a slide basically just kind of a real starting point, real starting point in terms of like where you're going. You need to identify the need for the legal assistance. Unfortunately, we don't always get clients who are having some education issues at the greatest point. Sometimes we have an IEP meeting tomorrow, unfortunately, or we have a client who has contacted us and they've made multiple requests for an evaluation of services. And that's kind of a good point to where you would focus on getting a demand letter to the district or something. So you really need to identify what are the client's options right off the bat. That could include a mediation, or unfortunately, it might be so far down a part to where you're going to have to do a due process complaint, which we'll talk about towards the end. And then, does the child need additional school assistance? I noted that because it's often the case to where we'll get a referral for from a parent, and the child's actually receiving services in the school. So they might have a 504 or an IEP already in place. But due to the child's disabilities, or even something that could have occurred within this school year after an annual review or something, there really needs to be a review or a special review to accommodate the student due to something occurring. That could be trauma or a wide range of things. But also, it's important to identify if there are any other additional school assistance needed, because I'm thinking of situations where there are resources in a school that might not be just appropriate for a 504 or an IEP. For example, a student had an evaluation and it didn't identify any mental health issues or disabilities or anything. However, there's something occurring in the home setting, or there could have been something traumatic occurred throughout the year to where the child really could benefit from some mental health resources. And the district that we're in actually has grant programming within their district that offers mental health resources. That doesn't necessarily mean we need to go a 504 and IEP route, but it might just be an issue to where you as the advocate need to bridge the parent and the child to some available resources in their district. So that's why I include that one. And that's one that's pretty important in terms of just identifying their need. And it's technically not really even legal assistance, but you're helping them navigate into the appropriate route of gaining the resource. And then which level of assistance is most applicable? That's going to be your biggest thing in terms of it, especially of an attorney here, is receiving that referral, listening to the client, and identifying which one's more applicable right off the bat, whether there's a listed disability or not. And we'll talk about that in more detail here in a little bit. And then who are the child's current advocates? That's probably the biggest thing, honestly. You can I've learned that the parents are the biggest driver in terms of IEP meeting. Any attorneys who are listening today know that things change immediately once an attorney steps into an IEP meeting, whether it's, whether it's an issue that's already arisen or not. Um, Sometimes it's not always for the best. I mean, really, the parents are the ones who usually get things done, and it's amazing how much can get done when there's an active parent who's really advocating for their child right off the bat. And then always know your procedural history, what's happened so far in terms of what the parents have already done before they came and sought assistance from you. And we can go to the next slide, Christy. So this is just a basic slide for those navigating whether to go through the 504 plan or an IEP. Again, for the 504, you'll look at the Rehabilitation Act, and it's a very broad definition of disability as in comparison to the IEP under the IDEA. So that pretty much immediately when the client comes to you, the parent's going to know what the child's been diagnosed with or what their disability is, and you'll be able to narrow it down pretty quickly in terms of whether that should fall under the IEP or not. You're paying attention for the 504 plans, whether that documented disability necessitates reasonable accommodations based on a substantial limitation on a major life activity. And that's meant to be fairly broad. You shouldn't have a lot of issues gaining the 504 plan if there is a documented disability and it's having an impact on the student's ability um, to basically keep up with their educational goals and things like that. For the IEP, again, I'll just note here, state and federal funding. There are those 13 qualifying disabilities, and we'll go over that here in a minute. Necessitates change in the services and or learning environment, and it is greater protection for your client. We'll go over the IEP here in a little bit and really discuss all the things that are included in an IEP. Sure, the 504 plan is more appropriate sometimes than the IEP. I'm not suggesting that everyone needs to shoot for the IEP because sometimes, a 504 plan really is the one that you should be going with. But in terms of documenting services and documenting progress along with the goals that you list out in the IEP, it's completely different when you're looking at the two plans. And in practice, I've noticed that there are more children placed on 504 plans as opposed to IEP, and I wouldn't say that it's intentional from a district standpoint to just put students on 504 plans instead of IEPs. But I have noticed that students who are on 504 plans really would benefit from being on IEP and do qualify for an IEP. So I think that when you are receiving a referral from a parent who's having issues with their children's special education, it's important to just pay attention and maybe backtrack a little bit. Don't just assume that because they're on that 504 plan that that's the plan that they need to be on. Make sure you're really getting that background information and identifying the disability and its impact on their educational goals. The next slide, please.
For some reason, I keep clicking and nothing's happening. Sorry about that.
No, you're good. If you want to back up, I think one more. Okay. So I kept this slide up before we broke off between the 504 and the IEP plans because they are very similar in terms of how you initiate the process of gaining the resources, and that both plans include a formal request for services and evaluation. So from a parent standpoint, you do need to make that written formal request, whether you believe that your child should fall under 504 or an IEP plan. And of course, our legal advocates listening in too should advise, clients that formal written request has to happen regardless of whatever services are later on implemented for the child's education. And that written request should be through the school administration. As a general practice, I would say always send it to the SPED coordinator, and that's usually, you can find that online for just about every district or the principal, and sometimes even loop in the teacher. I think as a good rule, just send it to everybody as possible. Send it to the teacher, if there's assistant teachers, if there's a SPED teacher, a SPED coordinator, a principal, a vice principal, send it to everybody, just so everyone's put on notice that you're requesting some sort of service and evaluation for your student. And that, again, we say all this, but it's going to be very client specific. So um, we'll talk about this in a minute, but the major pitfall is that parents don't know that it needs to be a written, or there's some sort of relationship with a teacher, which we would hope that they did have some sort of relationship with the teacher, but they say something orally or verbally to the teacher and they mention it, and it's just kind of left at that, and then nothing actually gets developed and nothing actually gets requested in terms of services evaluation, or no consent gets sent to the parent. So we list that as one of the common pitfalls, is the verbal request. So make sure it won't be uncommon to receive a referral for a client having issues with securing special education, and that's usually what has happened, is there's been a verbal request and nothing's been documented. And now that we're going to break off, I'm going to let Jay discuss the 504 plans in detail.
All right, good afternoon. We'll see you guys again. So when requesting a 504 plan, the first thing you want to do, as Josh stated, is to write a written request. And I second that the written request needs to be addressing everyone that you can address. So address the principal, the vice principal, the teacher. I know in middle and in high school, the students have counselors, so also address the counselor as well. The counselor, number one, is going to be familiar with your child in some shape or form. And then also you want to just make sure that you've crossed all I's and crossed all T's and dotted all I's. And so there will be no excuse as to no one knew that you made this request, because you made the request to several people. And any supporting documentation that you may have that'll lead you to believe that your child or the student needs a 504 plan, please attach those documents as well. After that, the school is going to get together. They'll read over your letter, and then they're going to evaluate your child. Your child's evaluation is going to be free. The district is going to pay for it. And so they will have an evaluation. Now, after the evaluation, there'll be a conference, and that's when everyone is going to come together to discuss the findings of the evaluation. And once that takes place, they will have a conference with the teacher, the parent, the vice principal, and the 504 coordinator. And then after that conference, they will actually develop the 504 plan. They'll develop it. And then after that, you can have a meeting to go over those developments, and it'll just explain what the 504 plan, what the ramifications of that plan are. So with this plan, he's going to get 15 minutes downtime every 2 hours so he can decompress. Whatever those ramifications are in that plan, they'll be discussed at this meeting. Now, parent involvement is not required for a 504 plan, but of course, parent involvement is encouraged. So as involved as a parent can be, do that. And then there will be periodical evaluations so we can come together and discuss, does a student still need this plan? Is this plan still working? Because a 504 plan is just a work in progress. So it's what we believe, is what the school believes will help the student learn best. However, it may work, but it may not. So at the beginning, it may be every month you all come together to meet to discuss whether or not the plan is working. And if not, you'll try something else. If it's working, of course, you'll continue on with that plan. And then as the school year goes on, you will meet less and less, because meeting just won't be necessary. However, you can always request a meeting at any time. You don't have to just meet every 3 months, because that's the agreement that you've come to. If after a month you feel a meeting is needed, then you can request that meeting. All right, Christy. So in the 504 plan, I stated some of this, but it will have your specific accommodations, your child's specific accommodations, whatever supports the child needs. So if the child needs to meet with a speech pathologist or whatever, that will all be listed in the 504 plan. whatever services are needed to address the limitation. That will also be in the 504 plan. It'll have who is supposed to give these accommodations. And that's very helpful. So if you notice that the student is not getting the accommodations, you'll know exactly who to contact because that information will be in the 504 plan. Also, whoever is responsible for ensuring that the plan is implemented, which is usually a school counselor or the SPED coordinator, their information will also be on the 504 plan as well. So you'll know to contact those individuals if by chance you want to have a meeting, if you feel that the accommodations are not working, or you just want to discuss the possibility of new accommodations, you will contact that individual. Okay, so FAPE is free appropriate public education, and this is really the basis of Section 504. And what it is 504 requires that each district provide free appropriate public education to all students, regardless of their disability. And this really just says that all students have the right to an education, whether they have a disability or not. The nature or severity of the disability is not important. It doesn't matter what disability they have. That does not matter. They have the right to a free, appropriate public education. And Section 504 defines a person with a disability as anyone who has a physical or mental impairment, and that mental impairment substantially limits one or more major activities. There must be a record of that impairment, or there's a record of that impairment, that's an or is regarded as having such an impairment. So major life activity could be anything from bathing, it could be speaking, hearing, whatever that life activity is, it does not matter. They are obligated, they are entitled to FAPE.
Would this be a good point to interrupt you guys for a minute?
Yeah.
I wasn't sure if you were switching off. I was trying to fill some of the questions. Can you guys see when I look at the chat box, does it pull down where you guys see it too? Does everybody see that?
Question?
You guys don't see it when I pull it down?
Oh, I don't.
Okay. All right. Also, I just didn't want it to interrupt your presentation. So I had been not fielding questions for that reason, because whatever's going on my screen here. But while we're stopped for a second, I do have a polling question I'd like to throw out there. And this one is just to, again, for attendance reasons, but also to help me out. Where do you send in your completed CLE form by May 28th, which is next Friday, to receive credit for the CLE? And just as a reminder, we have to turn in our CLE forms within 15 days of the presentation. So we get a lot of people who send them to us late. We really need you to get them to us within a week, so then we have a week to verify attendance and get them sent into the Office of Professional Conduct. I'm sorry, Office of Professional Programs, not Conduct. Right now it's a really busy time for them, with it being the end of CLE year. So it's taken a little while for things to post. So please just know it's going to take several weeks for your CLE to show up. But you will get credit if we send you the form and say we had you here, you send in your form, you're going to get a confirmation from us we received it, and you will get credit. So I'm going to go ahead and end this poll. The answer is CLE@arkansasjustice.org. Please do not send CLE forms directly to staff members. It causes a lot of confusion on our end and just kind of floods our email boxes. And I'm sorry about that, guys. I will hand it back over to you.
Thanks, Chrissy. If you go back one slide, please. Okay, so I'm going to be talking about the IEP specifically now, and we'll go over IEP eligibility. The plans are designed for children between ages 3 and 21 with a qualifying disability. We'll talk about in a second what that means. That negatively impacts his or her educational performance and necessitating special education related services. So I made a couple notes in here, a couple tabs, especially for my parent advocates in terms of identifying available resources for them. That you will note that in terms of the IEP under the IDA, the eligibility includes children 3 to 5, so before school age services. That's important to know in terms of attorneys too, for clients who are reaching out to you with children with disabilities and who could benefit from special education resources. So those are available for them. Also, we should all be aware of the child find requirement under the IDA. The school districts not only have to identify the students within the classroom setting who are having educational performance issues due to a disability, but they must actually have to go out and find those students as well. And in terms of implications for homeschooled children, there are available resources for them too. You don't have to be quote unquote enrolled and going to the actual school to receive those services. And I included a little plug in here about the extended school year services too, because that's also available for especially children who are already on an IEP within the school district. Those are available, and there are different requirements, and there are limitation things to um, to address. There are limitations in how many people they can have within those resources too. So it's a little different, but there are extended school year services available. Christy, can you go to the next slide, please? So these are the disability domains listed. When I keep on talking about what a qualifying disability is, I'm not going to go over each one of them. If you wanted to screenshot or keep, so you can have it for your own files in terms of the list of disabilities there. I would make a note specifically when it comes to that other health impairment. I've seen that a little more frequently, and that it is actually defined within the IDEA. It just means having limited strength, vitality, or alertness, including heightened alertness to environmental stimuli that results in limited alertness with respect to educational environment, that it's due to some sort of chronic or health problem. So it might be an avenue for resources for some other children who have a disability that might not be listed right there in what you would consider the disability domains. And whatever that chronic or acute health problem was, it was adversely affecting their performance, the educational performance. So just keep that in mind in terms of, if you don't see that, don't automatically assume that they'll have to go on a 504 instead of an IEP. And Kristen, I'm ready for the next slide. Sorry. Sorry, I lost track of where I was. The IEP plan process. So it's very similar to what we just watched with the, sorry, I'm trying to mute my other things that are, dinging on my laptop. So the IEP plan process, I'm still on the one before that. Sorry, Christy, I'm confusing you. It's very similar to what we just talked about Jay just talked about for the 504 plan. There is a written request and a referral made to the school principal, SPED coordinator, and you would also send in client supporting documentation. I will note, back when I talked about the referrals at that very beginning before I slid off, that I know some parents don't know how to get that information in terms of actually calling the school, getting the principal's emails and all those different individuals' emails. Every school district should have a contact list with those individuals listed on there. I know Arkansas is very rural in some areas, but there should still be a website that has everyone's emails listed to where you can send it to everybody fairly easily. In addition to that written request and referral, you will need to send a consent, and everyone's a little different with that. There has to be consent before an evaluation can ever take place. But some school districts will send back a consent form to have on file within the district. It's the actual form that the district has. I would advise sometimes just send a consent form in with a written request and referral, so that there's already an established consent for the evaluations. But again, just know that you will have to, as a parent, have to provide consent for the evaluations to actually take place. There's a conference before the actual evaluation and eligibility determination, and that'll include the entire care team. That should include the teachers, obviously the parents, definitely the parents, and the SPED coordinator. Sometimes there are other potential parties. And I only mention that because there are situations to where a child might be receiving services already, but not within the school district. So they might be receiving OT, physical therapy, or speech services somewhere else. And so there might be potential parties that would be involved in the IEP that would attend that care meeting that maybe aren't already involved with the child. Is the only reason I mentioned that. Because everyone would kind of be on notice that that was probably someone that will be involved in the care team if IEP does occur. And then there's the evaluation and eligibility. So in terms of what we would do, or if where we would see issues arise, would probably be a proper evaluation. And that could occur from, we already have documented disabilities for that child. And so we know what probably should occur after evaluation. And then based on the evaluation that's conducted by the district, where placement actually occurs. So what resources are actually given to that child after the evaluation. And I remember seeing a chat in here, Christy, somebody was asking about independent education evaluation. We're going to talk about that in just a second. And that again would stem based off of this evaluation and eligibility that we're talking about right now. So after the original evaluation eligibility determinations, we'll have a second conference. And that's when usually the school counselor, whoever did the special or whoever did the evaluations, sometimes it's somebody within the school or somebody that's hired in contract with the school. Regardless, all that information is given to the care team, and then we all discuss it, and the IEP is formed. You go over based off what the evaluation identified as being the child's disability, or what was identified as being their barriers for their educational goals. And then within that second conference, you basically, the result of that is the IEP. And then after that, there's still continued meetings, and there's still continued back and forth between the care team. It doesn't just end there. There are annual IEP meetings, and I would note that there also are differences. And again, this is very child specific in terms of progress reports. Some IEPs will require weekly updates with parents based on the child's disability if there's something specific. And I'll talk about here in a second one specific case that always comes to mind that required kind of constant communication between not the entire care team, but the SPED teacher and assistant teachers within the classroom because due to this child's disability. The evaluations, I think there was maybe a question in terms of the evaluation that maybe speaks on this. There are federal requirements in terms of how that evaluation is conducted, who can conduct that requirements. I'm not going through those specific details in the CLE, but there are. It can't just be somebody who doesn't have any training in providing therapeutic evaluations or whatever evaluations we're talking about here. They need to have some sort of training and background in that. And then also that students can't be assigned to SPED classes only on the basis of intelligence tests. This care team and the evaluation is a pretty lengthy process. It includes a lot of different things. It includes information from parents, information from the actual teacher that's involved right now. It's very client or very child specific. It's not just based solely on that intelligence or whatever intelligence-based test that they did. And again, it just should be a carefully thought out decision. And then any change in the placement must also include a reevaluation. So I know that sometimes we'll have issues arise after the evaluation eligibility was determined, and then something is changed later on without having the parent involved or without having an evaluation done at all. There would still need to be a reevaluation. And that's what I mean in terms of progress reports and follow-up meetings. And just to also remember that an IEP meeting or in the requirements and standards of the IDA also fulfills that 504 and Title II for an appropriate education for a student with disabilities. And Christy, we can go to that next slide. So those who are, especially attorneys, should probably just screenshot. I'm actually on the procedural protections slide, Christy. On before those. Yeah, so you should probably just want to screenshot this one. This is always important to know in terms of when the client comes to you, to keep track of if everyone's kind of followed the procedural protections for that student and the family. So when that referral is initially made, that district must schedule a conference within 7 days of that referral. Again, we're wanting there to be a written, documented referral, not just a verbal communication with somebody. And then the conference must be scheduled within 21 days of that. And then after that first conference that I just talked about, the evaluation must be completed within 60 days. And after that date of evaluation, the second conference must be held within 30 days. So these post IEP procedural protections that I've listed here, this is your annual review. And again, it's an annual review. It should happen every single year for those parents who are listening. And you should always receive notice of that. And I think that's something that's followed through fairly well. I've never seen anything kind of happen from that. And everybody who in the care team will be put on notice in terms of the upcoming review of the IEP. And again, reevaluations and special requests can always be made by parents or attorneys who are assisting the parents. Now, I added the note in here. I always think of this case revolving diapers. Actually, it's kind of an interesting case. The student had a disability that required constant diaper changing, and the parents have included in their IEP a diaper log. And those who have dealt with IEPs know this is probably pretty familiar in terms of a diaper log being provided sometimes either daily or weekly to the parents per the IEP. And in this situation, the parents reached out to us because the logs weren't being submitted to the parents. And not only were the logs not being submitted, but it was clear that the diapers weren't being changed at appropriate time. Diaper rash developed, other issues developed based on the diaper rashes, and it became a very big issue. And so that's the situation where we have to do a special request, a special meeting to have everybody sit down and discuss what's going on and why the procedures that are in place and for the IEP aren't being followed through. In terms of the post IEP reevals, just also note too, especially for parents who are listening, that the parents also have the right to examine those child's records. I know I went off and talking about the IEP and then you having access to the IEP, but it would be inappropriate to just assume that a parent has the IEP in hand. That's definitely not the case. I know from where I come from, parents don't have the IEP usually on hand, and they maybe didn't even know that they had the right to have the IEP with them. So again, that parents also have the right to examine their child's records, and that includes the IEP plan. That's basically a contract between you and the district. And Christy, I'm ready for that next slide. So I included an example of an IEP in here. I thought it'd be very beneficial for attorneys who aren't practicing in special education right now. I'm waiting for that slide to come up. Okay, so everyone is a little bit different. Again, I'm from Tennessee, so I know our forms look a little different than Arkansas. So regardless, the IEP should include an annual goal at the very top of the page. It might also just be listed on every single page within your IEP. This one included provide measurable annual goals, including academic and functional goals to enable the child to be involved and make progress to the general education curriculum and to meet other educational needs that result from the disability. That's pretty standard in terms of your annual goal. Obviously, we want to do everything we can to make progress in the general education curriculum for the student. Now, specifically, you're going to have your goals listed, each one. I included just one in here, and this one was based on reading. And you can see it gets very detailed. Not only very detailed, there's also a portion in there that says the progress towards goal will be measured by. That's very important. Not every goal will have that, I've noticed, but you should, in terms of the goals that you're really identifying for your child, if they're having issues with the reading scores, or if they're having issues with spelling or math, you want to be able to see right here on the progress towards the goal, what exactly are we looking at in terms of identifying if they're making progress towards that goal. And here we're obviously looking at grades, work samples, teacher and text tests, and curriculum-based assessments. And the next slide, Christy. And I included this little graphic. This, I think all attorneys would agree, you start getting into math and I don't know what y'all are really talking about. So this is a really important thing to look at in terms of if you're representing a client with resources or a client who's receiving speech or OT or PT, because they're going to break down specifically how many minutes per this IEP and how frequent that student should be receiving those services. And from my experience, this is where the major issue comes in terms of special education resources. A parent is not satisfied with the goals that have been identified in the IEP, and they're not satisfied with how much resources, how much time is being designated towards that specific goal based on the disability. So if the child's having issues and I'm trying to think of a specific thing based on speech or PT or OT. And instead of when a reevaluation occurred within a year and it came with a decrease in time, that's usually when parents become very frustrated and upset and will reach out to a legal advocate because they're not understanding why my student would be getting a decrease in services when they haven't increased their goals or their progress towards their goals listed in their IEP. And so we have to do a little math. We have to think about how much are they actually getting it every day. If they're receiving the service every day, should the IEP be adjusted to where they're receiving a certain amount of hours every day based on the total amount of hours they're getting? So it can get a little confusing in terms of making sure that, yeah, 240 minutes seems like a lot of minutes when you're looking at that. That's a month. That might not be that might not be the amount of service that child actually really needs. So in terms of actually having issues with IEPs, this is probably the major thing that I see is actually time allocated for services based on speech or OT, PT, and things like that. And then read the next slide. Okay, and we were obviously going to be focusing on the common pitfalls, which each of the things we just discussed about within the 504 and the IEP plans. We've already talked about kind of a lot with the referral issue, making sure that you're identifying that with a written communication to all your contacts at the school district. Your evaluation, now your IEE, that's that independent of education evaluation that we talked about. I mentioned that I was going to talk about. In general, and I'll say in general, every parent has the right to have an independent educational evaluation done at the expense of the district. There are situations where that wouldn't occur. I'm not going to go into that, but yes, you do have a right to an independent one. Something could occur during that evaluation to where, based on the child's records and the services they're receiving outside of the school district, this child has documented a history of this certain disability or this mental illness, and for some reason that didn't even either wasn't tested for during the evaluation or that didn't occur in the evaluation, and something just looked suspect. That would obviously be a case to where a parent or a legal advocate would think we probably need to have an independent evaluation done to just make sure that everything was captured in terms of evaluations for services later on. Now, in implementations, the common pitfalls tend to be follow through of the actual goals listed in the IEP. And that's not to say the district isn't doing it intentionally, but things just fall through cracks sometimes, I'd imagine, or whether there was a change in plans. And I listed the stay put rights, especially for the parents and legal advocates listening, that you have the right to have everything put on pause in terms of if there's something going on in the school or the district is wanting a reevaluation done. In the meantime, during that process, you have the right for your student and your child or client to continue receiving the services that were initially laid out in the IEP. And that's just something to make sure you're aware of if you're representing a client. And then your annual reviews, always make sure you have notice. There are instances, I haven't seen it, but where a parent wasn't given a notice, and I wouldn't imagine the IEP even going forward, honestly. I'd imagine it being rescheduled, but just make sure that you're getting notice and attending those IEP meetings on an annual occurrence. And that I say all these common pitfalls for the parents who are listening. That's not, I hope it doesn't come off that you're doing anything wrong or that you're coming at the wrong stage in terms of receiving legal advice. Education law is confusing. There's so many different things at play, and there's so many different requirements. There's so many different regulations that can go into play, and there's so much leeway, I would say, in terms of when you're looking at the Department of Education and actually the way that the IEPs and 504 plans are put in place and actually followed through. So it's okay to be confused and not know exactly what's going on in terms when you're reaching out for legal counsel, because even your legal counsel will have to constantly keep up to date. That's why we're having a CLE over it right now. And then also within your common pitfalls, I would say that just because the IEP states that something's being delivered doesn't mean it's actually being delivered or being delivered the way that it should be within the IEP. I know that when I receive a referral for a special education issue, when I'm going over the client background and the situation, I get the IEP. That's the first stage we do. We get a release information. We look at the IEP, actually go over it in detail and see what actually is the client is receiving. Just because it says they're getting all these services in this amount of hours doesn't mean that that's necessarily what's taking place. So I would just keep that in mind if you're a legal representative and somebody reaches out for you. Like, make sure you're getting all the factual background from the student or from the family, the parent, because just don't take the actual IEP in hand as proof that everything's being followed through. I'm ready for the next slide, Christy. Okay, so I included this slide kind of going into the due process issue that Jay is going to talk about. So when you're having these meetings, anybody who, I think it was a small percentage of people who said they actually had firsthand experience dealing with this, with special education, but it's very different, I think, in what you would imagine it would be representing a client. You're going into usually a very small room in a school that's not meant for opposing counsel meetings or a room for attorneys to be discussing an issue with a student's rights. And sometimes you're in the middle of a cafeteria and you can hear the intercom going off, you can hear kids running around in other rooms and things like that. So it's important to keep in mind that while you're having this meeting, that it's still a very serious legal proceeding. You need to prepare as if this issue will always develop into a due process claim. Not to say it will. I've had luck that hasn't happened, but it could very easily develop into due process claims. So you need to format your questions in a way to develop information, and you're basically to develop rights to discovery in the future for a possible due process claim. So always consider your right to discovery. And is your current issue related to a systemic issue? Again, I talked about at the beginning about legal aid, and we're always trying to focus on upstream issues or upstream remedies in terms of actually identifying a systemic issue versus in just, putting out fires constantly downstream. So is this something that's going on? This something that is addressing your client right now? Is this a district policy issue, or is this a practice that just needs to be changed? Is this a state issue that needs to be changed, or state policy? And then never be afraid to do some FOA requests. Request a copy of that internal policy on what's going on to address some of those systemic issues. And then I include this factual background because this meeting that you're going into, you really need to know that client situation forward and backwards. You need to know about those conversations that weren't written down on anything, aren't documented, that your client had with a teacher or the SPED teacher or the assistant SPED teacher or somebody else within the school, so you can develop those questions for that legal framework in the future. Of course, review your previous requests, the parents' previous requests, and review of school records. And of course, you'll do your client interviews and interaction over the records. And so just note that this proceeding is very informal usually, even though it could have very formal implications, and also be cognizant of your audience. You're not only just dealing with people who don't have the background necessarily in law, you're dealing with like an IEP team and those sorts of situations, but you're also potentially dealing with a state board of education or a state court. I think that's all I want to talk about that one. I will let Jay jump into the FBAs and BIPs.
All right. FBA is functional behavior assessment, and it's used to identify a particular behavior that interferes with the student's learning. So, for example, if the student has just random outbursts in the class, whatever the case may be, this test is used to identify what behavior does the student do that interferes with their learning. The test identifies factors that support the behavior and why does the student even do this behavior in the first place. And once all this data is compulated, we use that in order to create the behavioral intervention plan. And the behavior intervention plan, which is the acronym is BIP, it is used in order to implement tactics that the teachers and the student can use collectively in order to curb that behavior that led to us needing the FBA in the first place. So the BIP is used in order to create effective solutions to the behavioral issues. It takes into consideration the child's behavior and why it happens, like I just said. And we consider those considerations are called the child's communicative intent. So what intent does the child have when they are participating in whatever behavior that's disrupting their learning, and then implement a BIP in order to curb that behavior so the child can learn effectively. All right, Christy. Okay, so we have the Manifestation Determination Review, which is also called the MDR. And this comes into play when your child has a 504 plan or an IEP, and they are up for expulsion or suspension. Now, a child can still be suspended or expelled even though they have a 504 or an IEP. However, they just have a little bit more protection, well, a lot more protection than a student that does not have one. Now, an MDR only comes into effect if the suspension at hand is going to be for more than 10 days, if they've already been suspended for 10 days or more this school year, or if the suspension is going to be approved, they'll have been suspended for more than 10 days when they return. So for example, if they've been suspended for 7 days, and then this suspension that they're facing now is going to be for 5 days. So that means they've been suspended for 12 days once they return. So before this 5-day suspension, they have to have a review. Or if they're being expelled, because of course an expulsion is more than 10 days, so you'll have an MDR. And the purpose for this review is to determine whether or not the behavior that the student is accused of committing is that directly linked to the disability that has already been found that they have. So did the student set off the fire alarm because of whatever disability they have? Is them setting off the fire alarm related to that disability? If it's found that the act that they've committed is related to the disability, then the review will state that they are not to be expelled or suspended because they couldn't help the act that they committed. However, if the act they committed had nothing to do with their disability, then the suspension or the expulsion will go forward as though they didn't have a 504 or an IEP plan. Now, it's important to note that before the review, because there are times, at least in my experience, when I have no connection, I have no prior history with the client before the parent got the notice that they're going to have this review. So before the review begins, you do have the right to request the file and ask for the file, even in that moment, a few minutes before the review. Of course, it's better to ask for it as early as possible, just so you can review and be very familiar, as Josh stated earlier. You can be as familiar as possible with the file because you do need to know it backwards and forward. But there are certain things that you definitely need to understand, like such as what is the disability, what has been put in place in order to help the child learn in accordance with FAPE. So right before the hearing, if that's the only time that you have, you don't just want to go into the review and wing it. It's not like a wing it situation. Make sure that you request the file and ask, can you see the file so you can see the IEP, see how many days they've been suspended before this hearing to understand that, see what the disability is. Have there been any other behavioral problems before this incident, and what was done as a result of those problems. So you want to know all that information before the review even begins. So if the review is your first time dealing with this student and being in that situation with the student, then ask for that documentation before the review begins. All right, Christine.
Hey, Jay, I hate to interrupt you. Just to let you know, it is actually 1 o'clock right now. I'm not sure how many slides you have left, but just a heads up that we need to kind of wrap it up. And we also have 15 questions. So it's up to you two if you're able to stay on and maybe answer some questions. But just want to give you that heads up.
Okay, I think there are only a couple of more slides. So.
Okay. Oh.
Okay, so the ALE, the Alternative Learning Environment, and the purpose of the ALE is to assess students either before or upon entry into the ALE, and to provide intervention services designed to address their special educational needs. So they're going into a new learning environment because they've gotten this IEP plan or this 504, so they have these new accommodations, and now we're trying to see whether or not we're trying to provide intervention services designed to address the educational needs. And so in doing that, they're going into an ALE. So intervention services include access to services for a school counselor, mental health professional. If their disability is physical, they may need a nurse. Whatever support services are necessary and listed in the IEP and 504, all of this is a part of the ALE. The ALE must provide special education and 504 services, and a student must receive the intervention services designed to address their behavioral needs. So pretty much we just cannot ignore the behavioral needs or say, well, we see them, but we really don't know what to do with this behavioral need. No, a solution must be met. And that's when the ALE comes into play, and we use the documentation and the data that we've collected in order to create this alternative learning environment. Also, and this is very important, the ALE cannot be punitive, meaning it cannot appear to punish the child for whatever the behavior is. The purpose of it is to aid and to help, not to punish. All right, Christine. Now, there are times when the IEP and the 504 plan are not followed as they should be. So in that case, you may need to file a due process complaint. So the first thing you want to do is first try to handle the issue in-house. So you will file your written complaint with the 504 coordinator, just explaining whatever the issue is, whether my child's not getting accommodations, which during COVID, when everyone was learning at home, that was a big issue, that the accommodations were not being followed because schools were not trying to figure out how to give these accommodations during COVID. So that was a big issue. The first thing you'd want to do in that instance is to contact the 504 coordinator, explaining that my child or my client, they're not getting the accommodations that they are guaranteed, and we need to do something about this. Now, if the 504 coordinator does not address it, or if they do address it, but they don't address it properly and nothing changes, the second step will be to go to the Office for Civil Rights, which is a section of the U.S. Department of Education. And you'll file a complaint there explaining that you previously filed a complaint with the 504 coordinator. This is what happened. I filed this complaint because my child's accommodations are being ignored, and give them an opportunity to cure. Now, if they do not cure, then you'll file a complaint with the Equity Assistance Center, which is a different division, but also linked to the Department of Education doing the same thing. I've already filed a complaint with the Office of Civil Rights, nothing happened. 504 coordinator, nothing happened. And then your final step will be to file a claim in federal court. You will only file your claim in federal court if all the other steps have been exhausted and there's been no changes made, or those changes have not effectively cured whatever the issue was in the first place. All right. You also want to be sure that you understand that there is a statute of limitations for filing a due process complaint. You have 2 years from the time that you knew or should have known of the violation. So using Josh's case with the Pampers, for example, let's say the IEP did not ask for diaper change information every single day or every week to go home to the parent. However, the parent saw after a couple of months of improper diaper changes, their child got a rash. So the 2 years will start from the moment that they noticed the child got the rash, because that's when they knew or should have known of the violation. You saw the rash, that's when it begins. Battle of the experts, you want to consider medical evaluators who would take parent insurance, graduate school, and hospital systems. That's very important. And also you want to make sure that you understand there's a time commitment, a significant time commitment, because you may have to go all the way to the federal court. Also, there may be an appeal process because you may not win in the federal court, but you still can appeal. So that takes time. So you want to keep that into consider. We want to take that into consideration. That's more so for attorneys. In your settlement, pay attention to the waiver of claims. You want to make sure that you haven't waived any claims, haven't said that I'm not going to sue if X, Y, and Z happens. Make sure of that. And also, it's possible that school districts don't want to go to court, so they may try to settle before the court process, which is beneficial and helpful. So also give that opportunity for that to take place. All right. And these are just the resources that we use in order to put this presentation together. I guess now we can answer some questions in our Q&A.
Okay. Do you want me to just read them to you?
Yeah, that's fine.
For those of you that can't stay, as long as you're here for 60 minutes, you'll get CLE credit. For those that would like to stay, we're going to try to answer some of these questions. We've had like 30 questions. I've answered 11 so far. So we'll try to answer as many as we can before we drop off of here. So the first question we had, and while this is going, I'm going to launch another poll question. Where is the first place to start if the parent thinks their child is not receiving proper services and accommodations?
So first, you will want to, and that's actually what I just went over with the 504 coordinator. Reach out to your district's 504 coordinator. You should be able to find that on the school's website or the district's website, and figure out who that is, and just write a letter explaining, you know, my child does have these accommodations due to this disability. However, they're not being honored. And so I would like to have a meeting in order to discuss what the accommodations are, why they're not being honored, and what we need to do in order to implement those accommodations.
Okay, next question is, are there any special distinctions or things of which we should be aware as between primary, kindergarten through 12th, versus secondary, college education for special needs persons?
Well, I know for in college, you know, you get the special accommodations. You'll give those documents to your advisor. But as far as any differences, I'm not aware of any, Christy.
I don't, you know, I haven't. I've helped request reasonable accommodations for post-secondary, but you know, you don't have an IEP or a 504 plan, so it's a very different process. But I can tell you, you know, a lot of schools, like for instance, UALR, they don't even request the documentation. You go in there and you tell them what your disability is and, you know, what reasonable accommodation you're requesting, and they will consider it and typically won't even request the documentation. So depending on what school district it is, I mean, what school district, which college you're going to, some of them are very, very, very accommodating, and others you may, if you get pushed back, you may need to seek some legal assistance.
Yeah, and I would definitely say it's just like the law still applies. Like so your section 2, like the things that we've listed out in the CLE, like the applicable laws, those still apply in that situation. It might be different in terms of like actual procedures that apply under those statutes, but the majority of those protections still apply. So keep that in mind.
Okay, next question. What is the school's obligation to let parents know a 504 is an option? Recently, I had a situation where the school was actually negative to the parent because the parent did not make the request. The parent did not know they needed to make the request.
So I would say, I don't know if there's an actual obligation for the 504. I know like the obligation would be under the IDA, especially for your IEPs, for example. But Christy, do you have anything specific about?
Yeah, I would say school districts have a child find obligation. So they do have the obligation if they suspect the child has a disability and needs an accommodation in order to receive a free appropriate public education, then they have the obligation to evaluate the child. Next one, are all the choices the same? And I don't know where we were the slides to answer that one. So I'm sorry, unless you want to come back and clarify what you're asking about there. Does FAPE include equal education?
Equal education as to across the board between all students?
I would say, I mean, we don't know, they capitalize equal. So that's the way I understand the question.
I would say yes, because that's what the purpose of FAPE is, to make sure that all students have the same opportunity to receive the same education. So of course, there are going to be some differences because depending on what the student's disability is, there are certain things that they may not be able to gauge, but they're going to be able to get the same standard of education that a student who has no disabilities will receive.
Next question. I've had pushback from schools when requesting 504 plan services evaluations when the students' grades are good. This is pretty common. Can you address this and how to get help when this happens?
Well, I think from my experience, a lot of schools think that 504s and IEPs are only because a child is not able to function as far as learning, as far as their grades. But there are students with good grades who need IEPs because they may have other issues such as behavioral problems. So I would encourage you to bring those issues to the forefront when you meet with the school. Well, yes, I know my student makes A's and B's, but you also can see from their conduct that there's another issue. They have U's and N's. So we need to put something into place in order to combat that, because we know that when planning for the future with college, schools look at all of that. So a student that has good grades but horrible conduct, that might be a deterrent for a college. So you want to put some kind of a 504 plan in place in order to help start curbing that behavior before they reach adulthood. So I would just encourage bringing that information to the forefront and you have the evidence right there, I'm sure. Look at their behavior. They need a 504 plan because of this.
Right. And I would also add, when we were talking about the way these evaluations go and the requirements for the evaluations, it's not just the intellectual testing. There are a lot of factors that go into determining the appropriate plan and the appropriate resources allocated for that child's educational goals. And educational goals in itself doesn't just include high grades. So there are other things too. So that shouldn't be just the one deciding factor.
I just want to back up because I thought of something I wish I would have said, on the child find obligation. I just want to point out for those that don't know, schools are supposed to actively look for the children who need accommodations. It's not just, if it's in their face, they can't ignore it. They are supposed to be actively trying to find students in their district that, have a disability and have a barrier to their education to provide them reasonable accommodations.
District too, not just the school that they're in that we're talking about here. Yeah.
Next question, are teachers discouraged or prevented from initiating IEP 504 or requesting a parent to do so based upon what the teacher sees in the school?
No, they would have the front row seat as to how the student acts and how the student learns, because they see the student every day. So they will be one of the main individuals, other than the parent, who would notice that there's an issue and that a 504 or an IEP plan will be needed. I've had cases where teachers were the person to state that the child may need an accommodation.
Mm-hmm. And I will say I've had cases where the teacher was discouraged by the district and advocated for their student. I hope that's what all students would do. If you're a teacher and you feel like you could lose your job or that you have been threatened in some way by the district, you can always give the parent the number to Legal Aid or Disability Rights Arkansas to seek legal assistance. You can kind of direct them to where they need to go. But that should not be happening. It should be reported if it is happening. Next question, is there a set of standards on which the time spent on various IEP services are based?
Off the top of my head, yes. There are like guidelines I know, but I don't know them off the top of my head. We'd have to go in and look for them. So if you have a question about if there's an issue where you're having something not being provided, just reach out to Legal Aid or one of us. Our emails are at the end of the slide, and you can get connected.
And this is from Stephanie Flowers. I believe Arkansas legislator has passed a law that would allow a parent alone to decide a particular action should or should not be taken towards a child that is subject to an IEP. I think it had to do with corporal punishment. Can a parent alone make this decision, or is it to be made as a result of the IEP team? And does a manifestation determination come into play for behavior that may result in disciplinary action?
To answer the last part of that question, yes. The majority of the MDRs I've had were because of discipline. Disciplinary actions led to, or inaction, led to the need for a review because the student was going to be suspended or expelled. So I believe I'm answering the question by saying that yes, there are reviews do take place because of disciplinary issues. That was the question, right, Christy?
The thing about the parent,
So much.
the parent's decision, I would assume so, Christy. I don't know. But in terms of corporal punishment, that's the way I've always understood it. It is the parent.
Yeah, I know. I have had a lot of children with behaviors because they were on the autism spectrum. I've always advised them to revoke any consent they've given the school to use corporal punishment, because it's very often abused with those children when they're having some kind of manifestation of their disability. But I do remember vaguely hearing about that bill being introduced. So I definitely want to go back and look at that. We have a question or survey about if you're interested in a follow-up to this presentation. So maybe that's something we can look at if we do that. Next question for the IEP lawyer. Is he aware of any way to request that a private paid para be allowed to act as a children's para in Little Rock School District? We have been offered a Little Rock School District para for 1-to-1 for a new first grade. It says with D's. I'm not sure what that may be Down syndrome. I bet it's got a capital D, a small s. But parent would prefer the child's para to assist while there. Is that a possibility?
So the parents wanting a private paid person to assist in the school versus the person who's paid by the school district. That's the question?
Yes, yeah.
Okay. I do know that there are ways to have people who are outside the school district provide resources within the district for somebody who has an IEP. I would imagine that there are, procedures in place that the person can't just be there within the classroom with other students. The things that I'm thinking of is when, say, a student needs therapy or something, and then the IEP includes that because there's a way for that therapist to be on school campus or something within the district, or it's somebody in contract with the district to provide that resource. I don't know of a way to have a privately paid person provide services when there's that person available already there within the school district. And I'm assuming that's already included in the IEP. I don't know that.
If I were your lawyer, I'd argue you could do it. I don't, there's definitely a lot of considerations, because when I first heard that question, I thought, well, the school district might like that because it takes the burden of the, having to pay for the para off of them. If the parent's willing to pay for the para. But then too, there are the privacy concerns, there's, you've got a lot of stuff when you're in a school
on what services we're talking about too.
Mm-hmm. Yeah, because I know I've definitely had cases where we didn't like the school-based therapist that the school wanted us to use, and we, were able to get it switched to a different therapist. So I would say if that's something you have a problem with, reach out to legal aid. When I say legal aid, it depends on what area of the state you're in. We have Center for Arkansas Legal Services and Legal Aid of Arkansas on here. And so if you call their hotline number, which I'll put it in the chat, you will, they'll direct you to the right office. Next question. Usually if a contact for renewal of an IEP, usually if a contact for a renewal of an IEP, if the teacher contacts the parent 3 times for the IEP meeting, you can have an IEP meeting without the parent. Are the legal rights of the parent in that case? I guess it's what are the legal rights? That's what should have said.
Now, I know that you can have a 504 hearing with a 504 meeting without the parent, but I've never had an IEP meeting without the parent, even if the parent can only be on the phone. But the parent has always been present. Have you had that experience, Josh?
Yeah, I think there is something in terms of a requirement to make every reasonable accommodation to have the parent attend somehow. So that's usually done by phone. But I mean, I don't think that if the parent just doesn't show up or attend, it like, creates an issue for the IEP to be in place or anything. I don't think that's a thing. But I wouldn't know. I've never seen that. Usually parents are, available for the IEP somehow. Reschedules happen, of course, or they miss the first IEP, sure. And then they reschedule because they want the parent to attend. But yeah, I haven't seen that.
Next question. I frequently work with parents who are unable to attend their child's IEP meeting and at the time the school district offers. Do parents have a right in regards to when the meeting occurs so that they and their advocates may also attend without excess stress on the family?
Yeah, I'd say that they do have a right. I don't like have it right off the top of my head, but yes, definitely.
Yeah. Okay. Can you give some examples of how you can treat the IEP meetings appropriately in light of a possible due process claim, AKA maintaining discovery?
I'll leave the due process claims to you too.
Well, I mean, I would just imagine you would of course want to ask, you want to just make sure that you're asking the kind of questions that, I don't really know how to answer.
I think I know exactly what they're talking about in terms of the slide, and it's meant to be as just a acknowledgement that when you're asking the questions from the care team throughout that meeting, the very informal meeting that you like Jay was just kind of going at, you want to ask the questions that you know are going to be later on discoverable and that you can use in your benefit for a due process claim. So you're going to be wanting information, you gather as much information as possible within that meeting, that you can later use for your benefit.
Such as you might want to know about you might want to know about the IEP, what are the goals? You might also want to know how many behavioral infractions there have been this school year, maybe however many years they've been in that school, what solutions have they done in order to try to cure those behaviors from happening again. So those might be questions that you'd want to ask, depending on what kind of hearing it is. More than likely, it's going to be due to behavior. So you might want to ask questions tailored to the child's past behavioral incidences.
There were tons of questions about the slides. They were emailed out at 11:30. It got flagged as security. So check your spam and junk emails. If you don't have it in any of your spam or junk emails, you can email CLE at arkansasjustice.org to request a copy of the slides. Sorry guys, I had to screen through which questions are for you. What if a child is in private school? What services must still be provided? Do you want me to grab that one?
Yeah, I know you don't lose all your rights. I would just like to note that, but yeah, I haven't had to do it.
It is different. Yeah, I can't provide a definitive answer on that one. It's not the same as a school that receives public funding. But yeah, you do not lose all your rights. So if you're having problems in private school, definitely reach out to an attorney at Legal Aid. And if one of you guys happen to know the number, I'm trying to Google it and I cannot pull up the number to the helplines. If one of you know it,
it's 1-800.
Hang on just a second, let me pull up the chat and I'll put it in the chat. Maybe. I'm just gonna let you read it out. I can't get the chat up.
The helpline number is 1-800-950-58 17. And then when you, yes, and then when you call that number, they will forward you to whatever, whether it's Center for Arkansas Legal Services or Legal Aid of Arkansas, depending on what county the person lives in.
Okay, sorry about that. Okay, so I think this was a follow-up to the question we didn't get earlier. It says, thank you. School required a parent to attend field trip despite having LEAP accommodation for one-on-one aid, or would not allow the student to attend the field trip.
Yeah, I'd say that was, you just email us on that one or reach out to legal aid on that one for sure.
Yeah, you definitely can't not allow a kid to attend a school field trip just because they have a disability. Teachers have said they are discouraged by school to suggest an assessment because the school fears they will have to pay. And that's kind of what I was talking about earlier, that I have heard a lot that happens to teachers, but please don't let the school discourage you. If you can redirect the parent to get help elsewhere or be notified of their rights through an attorney, please do that. School told my son's therapist access through IEP that therapists could not suggest further evaluation for autism and said it was not her role to do so.
Contact helpline. Yeah, definitely.
So yeah, give legal aid a call because that shouldn't have happened.
Right.
More specifically, if a child needs a caregiver, for example, in parentheses, oxygen, diaper needs, etc., and goes to a private school, does the public school district provide the service?
No. Provide the service when the child's in private school?
Mm-hmm.
I wouldn't think so.
The only time there is some case law out there where the public school wasn't providing the child with reasonable accommodations, so the parent had to pull the child and put them in a private school that would provide them the accommodations. And the court actually ruled that the school had to reimburse the parent for those expenses. So I mean, it has happened, but no, it's not an automatic thing where if
Right.
you're, there's some,
I interpreted the question that I didn't interpret it that the child started off in public then went to private. I just interpreted like it was her choice or his choice to put the child in private school, but want the public school to pay for the accommodation. I know that's a no, but in your situation, I have read that as well.
okay. Yeah, so again, that's when you probably would need to talk more about the specifics with a lawyer for your situation. There's a law in Tennessee. If the parent is contacted 3 times without a response, the teacher can hold the IEP meeting without a parent. Later, if they want another IEP meeting, they are required by law to have one. So maybe that was in response to our other question.
Okay.
All right. That's all of our questions. Thank you guys so much for staying on here. We're almost 30 minutes over our time. But I think those were some really good questions, and I think you helped a lot of people. So I really appreciate that.
All right. Thank y'all for having us.
Thank y'all.